Thank you for joining us today, and joining me is Mark Costley. He's an elder care attorney with many, many years of experience working with older adults and their caregivers on estate planning issues. And we're going to be talking about the financial and legal sides of administration and preparations when a loved one is near death or upon their passing. Welcome, Mark.
It's nice to be here, Nicole.
It is great to have you, and I know when a loved one passes or when they get the news that a loved one's going to pass, this is just a very emotional time for family caregivers.
It is, and it can be stressful too, because typically you're facing things that you've never faced before, and often you're trying to deal with somebody else's business, and even though they're a close family member, you may not know about all of their affairs.
You don't. A lot of things come as a surprise for folks, and I think one of the biggest worries is doing right by mom or dad or sister or brother or aunt or uncle, and you know, maybe you don't have the financial means to pay those bills. What do we do in that case?
Well, that's right. It's a time when you feel a sense of duty, and so usually, typically in an estate, there is someone who is appointed to have the legal responsibility to make sure all the bills are paid. The great news, and there isn't much great news in this situation, is that none of the creditors expect to be paid immediately. They understand that the nature of an estate is that they're going to get paid if there is money, but that it will not happen immediately. And so you have a little time to collect all the assets, figure out what all the bank accounts are and what's there, and then figure out if there is enough money to pay the bills.
I think one of the most common misnomers, and I've learned it to be a misnomer because I've had to deal with this personally on several different accounts, is that folks think when they die, when loved ones die, so do their debts.
You know, they do not die. But one thing that doesn't happen that people worry about is that they get passed on. So when someone dies, their debts remain their debts. So even a spouse does not have legal responsibility for their spouse's debts unless they sign some sort of contract or agreement to be responsible. So if I have a credit card that's in my name only and not in my wife's name and I die, my wife doesn't have to pay that bill with her money, but she does, because she would be the executor of my estate, have the legal responsibility to make sure that my funds are made available to pay
Well, that makes sense. And that might be of comfort to folks hearing that, because I know that there's so much anxiety around death and dying, and a lot of it has to do with the financial pieces, for sure.
Well, that's right. And people really do worry about the timeliness of this. And I can't,
there's a sense of urgency.
I can't tell you how important it is to understand that these debts are not yours, and therefore you don't have to worry about whether or not they're paid timely. I mean, why do we pay our debts timely? We want to make sure that our credit rating is maintained, and the decedent doesn't have a credit rating anymore, and so we don't really have to worry about that. There is an exception to that, and that is something like bills for a house that somebody else is living in. I mean, if we have an electric bill or a gas bill or even a mortgage payment and somebody else is living in the house, well, obviously we need to continue to make those payments.
Speaking of homes, let's talk a little bit about real estate. What do we do? You know, a lot of times the biggest asset that somebody has is their home. Let's face it, that's where a lot of us plow our monies into. What do they say? It's a financial pit for all of us, right? Definitely. But say my mom died. How do I take control of that house? It's not in my name. What do I do?
In North Carolina, the law is not what people expect. In fact, it's not what is most common in the country. In North Carolina, when someone dies, if they have a will, and if the will controls the house, the house automatically belongs to the beneficiary under the will. And so nothing has to be done to get legal authority to have control. The executor doesn't have to give it to you. In fact, the executor doesn't even control the property. The executor, just to be clear, is the person who's appointed by the court to administer the estate. And they have control of all the other property that passes under the will, but they don't have any control over the real estate if there is a will.
You've been using the word will a lot, and unfortunately a lot of people die without a will.
Sure.
What happens in this state?
when there is no will, there is still an estate. It's just going to be controlled by statute.
So you're saying an estate. When I hear the word estate, I'm picturing somebody who has millions and billions of dollars.
That's right. The estate is more or less the word that lawyers and courts use to define all of the property. And so it doesn't matter whether or not it's a little bit or a lot. That's what we call the estate. And that property goes through the courts if there is no will, pursuant to statute. A lot of people think, oh, so the money goes to the state. Good news. No, the money doesn't go to the state, but it goes to whoever the state says in a series of statutes that have been set out over a period of time. It is an expensive way to die. You want to have a will if you possibly can, but rest assured that if there is no will, the property will still end up going to the family, unless, of course, there are creditors that stand ahead of the family, because naturally the creditors get paid first and the family gets the money next.
So if I was watching this video right now and I have a loved one who is going to be passing sometime soon but is still competent to make some decisions, is it a good time to bring up all this will business, or should we just let it go because they're near death?
I think even having the simplest will pay dividends for the family. And I also think that where you've got someone who's going through the process of preparing to die and they're competent, I think it gives them some comfort to know that they have, they've made a statement. They have put a tool in place that lets the family inherit the property, in a reasonable and orderly fashion. And that's what it does.
So what if there isn't enough money to pay all the bills? Let's just say we're in a situation where perhaps the person that passed just had very little financial means, or maybe all of their money went towards caring for this chronic illness. What do we do about paying all those outstanding bills?
Well, again, that happens through this court process that we call the probate process, where the executor, who is named in the will, is appointed by the court to make sure that the property goes where it's supposed to go. And as I said before, the creditors get paid first, but if the money runs out and there isn't enough money to pay all the creditors, then there's a specific hierarchy.
Oh, I was going to say, who gets first?
And so, naturally the government gets paid first. So
So your back taxes.
The IRS gets paid,
Okay.
the funeral homes get paid, not surprisingly, the lawyers get paid, and then we have secured creditors, like a bank that has a lien against the house. They've got a mortgage, and that is a secured interest, so they are entitled to get paid first from any equity in that house. They don't have a superior claim to a bank account, but they do have a superior claim to that house. And then after that, you have the unsecured creditors. So typically, the secured creditors are secure, that's what we're talking about, and they get paid. It's the unsecured creditors who don't get paid. Another thing I want everybody who's listening to know is that debts are negotiable. Everybody understands that when there's an estate, if they are owed money, they're not going to get paid for a while. And it's not at all uncommon to call up a creditor and say, I see where you're owed, $1,000. It's probably going to be a year or a year and a half before you get paid. We might be able to pay you, $500 now if you'd say that's all you need, and you'd sign a release and say we don't owe you anymore, and you can have that kind of negotiation.
Who's the you?
The you who's you being the executor having a conversation
Okay, so this
with,
couldn't just be a friend or a...
couldn't be a friend or family member. It needs to be that executor
Okay.
who has, the executor has legal authority to settle these kinds of claims, and that's what you want. You want to have, when you're alive, if you reach an agreement with someone, you sign a contract or you sign a release. Well, someone has to have the legal authority to sign for you after you've died, and that person who has the legal authority is the executor named by the court.
Let's face it, a lot of the stuff gets really emotional for family members. And so sometimes we'll say, oh, I've seen this, my belongings get split equally between all my 4 children. And then it's sort of a free-for-all, everybody piles on top of each other. And people are fighting over the Santa Claus mug that we put out, at Christmas time, or the special pen that Dad used to sign his bills with, or whatever it may be. How do we settle those disagreements? Because those are the types of things that rip families apart forever.
Well, that's one of the reasons I really think having that will is valuable, because hopefully we can speak to those things in the will, because what does happen is we become emotional when we lose someone we love.
Oh, yeah.
And if Mom told me she wanted me to have that mug, okay, it doesn't matter that she might have also told my sister.
Yeah.
I feel like that was a special bond between me and Mom. And so all of a sudden, I feel like I'm letting Mom down if I don't stand my ground and tell my sister, you can't have that mug. And that's not what Mom intended at all. She told us both we could have the mug because she really kind of wanted us both to have it, but she knows we can't share it. So you need to be specific.
I mean, really? That's specific?
Holy
cow.
I think about those kinds of things. That's why most people most lawyers who work with people doing wills or trusts or these kinds of things will say, let's talk about the property that's really important and let's mention that specifically, and then say everything else can be divided, equally or by agreement, and cover some of those things specifically.
And I've even heard family members who think ahead, which is, a lot of people are not proactive. They're very crisis driven. But I've heard of people, and some people act like, oh, this is sort of a cold, weird thing to do in the family, where they have family members kind of go around and write down the things that they want, or put their name on a little label in the back of certain items way before they pass away, so it's all settled and there's no There's no question in the end.
My mother put a sticky note on the back of every piece of furniture that she thought was important and valuable and said who she wanted to have it.
Yeah.
And you'd be surprised, but in the legal documents, when we prepare an estate plan, we actually refer to that arrangement. And we will usually say, and I may leave a separate written document that specifies who gets things, and I direct that be followed. And that becomes a way to sort of reinforce that legally if there's an argument. But usually
it's more hurt feelings, though.
Yeah, usually when mom does that, though, there's not an argument. So I think it's a good idea to label things or make a list. Understand that list is not legally enforceable unless the legal documents, make it so. But it does a lot to put the family's mind at ease and keep those arguments from coming up.
I would think so. And I know we're having a whole other segment about advanced directives, and you have to really be very careful about who you choose to appoint to be healthcare power of attorney, durable power of attorney, because you want to make sure they have your best interests in mind. What about this executorship? I mean, is that a really big job, not such a big deal? I mean, do you have to be careful about who you choose to do that?
Well, yeah, you should be careful about who you choose.
And why?
Well, because this person is carrying out your wishes. And so I think that if you choose a family member, that's the best possible thing if you have the right person in your family to do it, because they have a better understanding of what you really meant. As hard as people who draft wills work to make sure that your wishes are expressed clearly, it helps to have that read through the perspective of someone who really knew the decedent. And so naming a family member is extremely valuable, but you want to make sure you name the right person. I think the number one thing you're thinking about when you're picking someone is just responsibility. Who in the family does things on time? So don't name somebody, don't name your son-in-law who's a lawyer just because he's a lawyer.
Right.
Don't name someone who's a businessman because you think, well, maybe they'll be dealing with assets and need to understand that. Name them if they do things on time. Name them if they're the kind of person who balances their checkbook. But don't worry about sophistication, because the person responsible for these things can always get good advice from professionals who can walk them through this. Most important thing is to be well organized, to understand what the person's wishes were, and then to do things on time.
So if you were to give me a job description of an executor, what does that look like? For a typical, I'm not talking about a very complicated, but for a typical.
Well, so the main thing that people don't understand is the main thing an executor is a legal authority. So if you think about, I like to use the example of a tax audit, but not because it's a pretty thing.
So painful.
But it helps you kind of understand this. If you get a letter from the IRS saying they're auditing your income taxes, you cry and hopefully you don't have any kind of health-related event. But then you say, I've got some work to do here. The IRS wants money, or rather wants paperwork. They want documents, and you ask, do I need to get a lawyer to advise me about this, or an accountant, and you make that decision. If you're alive and mentally incompetent, who does that for you? Well, it's the person you've named in your power of attorney. But the instant you die, your power of attorney is no longer effective.
And I don't think a lot of people realize that. So
now, your power of attorney can't continue representing you in the audit.
Why is that?
Well, that's because the power or authority of the power of attorney comes from you. If you are my power of attorney, I have a document which I say, Nicole, I give you the authority to exercise my authority for me. And when I die, I don't have any authority anymore because I can't do anything. So you don't have any power because everything you got came from me. So now I have a will, and my will names somebody. It might name you to be my executor, but your authority as executor actually comes from the court. Because the court will look at my will and will name the person that I have nominated as executor in my will and say, that person is going to be the executor. Now the executor has the legal authority to continue to argue with the IRS, to represent me in that dispute, to in effect represent the family in that dispute, and make the choices. Do we give them the documents they want? Do we settle this? How much are we going to pay? How much can we afford to pay? So it's that legal authority that is the first thing you think about the executor having. Second thing is a responsibility to take care of things. Make sure that all the property is under control. I mentioned that the house automatically belongs to the beneficiary under the will, and the executor doesn't control it. But ironically, and this is kind of a pain in the neck, the executor controls all of the property in the house. So while the kids might own the house, the executor is in charge of the sofa and the microwave oven and everything in the house. Now, what the executor is obligated to do is give that property to the people who are named in the will, but the executor has responsibility for taking care of that property until such time as it's delivered to those people. And then there's a bunch of paperwork that the court expects you to file, all documenting what the property was, who received it, getting paperwork from
That seems all very overwhelming.
It can be, and so most people look for help, and sometimes the court will give you help with this process. I think the resources at the courthouse are increasingly stretched, and it's harder to expect that any of the clerks at the courthouse are going to be able to give you advice about that, and people typically turn to lawyers, and there are a lot of lawyers for whom this is a specialized practice area and something they do all the time, and I think that's something you want to work with that kind of person, mainly because they're going to have the staff who's going to be able to help you at kind of a lower cost, because you don't want some lawyer at $250 an hour doing all the work. You want to have an experienced staff helping with that.
Exactly. So a couple of things I've also heard around this time after somebody passes away that are very important. If you can help everyone understand why. First is the death certificate, and then the second are your articles of administration.
Well, so the death certificate is the sort of first legal document you have to have in order to administer an estate. Without the death certificate, you don't have the legal authority. No one has the legal authority to act, because that's the document that proves that this person has died and they are no longer acting for themselves.
So is there sort of a limbo period between death and you're no longer power of attorney, but you're not an executor? What's going on for those few days?
That's right. There is a limbo period of time, and we're fortunate in North Carolina. Typically, it's not very long. Might be 10, 15 days before you get your death certificate.
I mean, there may be some urgent matters you feel like you need to take care of.
Well, that's right, but understand there's some states where there are 3 months before you get a death certificate just because they don't have the resources to get it done on a timely basis. In North Carolina, the process is typically that if you go through a funeral home, which most people do, the funeral home, as part of their services, will help you order the death certificates. I think the standard advice that people get is to get 10 original death certificates. I rarely see an estate that needs more than 10, and probably typically it's more like 5, but it is so difficult to get additional ones if you run out that it's probably worth it to go ahead and get 10. So that's the first thing you need. And so often that may be the only thing you need. So imagine you have a checking account that is owned jointly with right of survivorship with someone else. Well, that other person has access to that account, but once they have the death certificate, they will actually be able to go to the bank and establish ownership of that account. So something as simple as the death certificate gets that done.
Okay.
And then you mentioned articles of administration. What you really get, that's what you get when you don't have a will. So when you have a will, the executor gets something called letters testamentary, and you're going to get asked for that if you're in this position of administering an estate.
That's very important.
Pretty often.
Is that equal like your power of attorney?
Yeah, that's what shows that you have the authority to act, and gives you the authority to collect money on a life insurance policy or to deal with a creditor or something like that. So it's important to get that. And then the letters of administration are what someone gets when there was no will, but the administrator is exactly the same as the executor, just a different title, because the administrator is a creature of statute. The executor comes from the will.
So creature of statute, basically the law says who's going to be the administrator based on where you fall in the rank of the family or some such thing.
Well, not quite that, but it says that there is a way to have to have an administrator even when there's not a will. And typically a family member will apply. If you're ever in a disputed estate, you need to know that anyone can apply to be the administrator. So if there is not a will, maybe that black sheep of the family who hasn't been seen for 20 or 30 weeks shows up and they want to be the executor or the administrator, and that can happen. But also, if no one initiates a court proceeding, even a creditor can be appointed as the administrator to administer the estate.
So these executors, it sounds like it's a job, really. It's a lot of hours of work. Can you get paid?
It can be a lot of work, and there are statutes that say that the executor is entitled to be paid. It's not a lot. It has to be approved by court, and it is capped at 5% of the value of the estate, plus a couple of other things that might be factored in there. So, even if there's a $100,000 estate, that means the executor's fees are capped at $5,000, and that doesn't mean they're automatically going to get $5,000. Right. That just means they cannot get more than $5,000. Okay. So they are entitled to get paid. Typically, family members who are also inheriting don't take a fee.
Yeah.
And that's because you have to pay income tax on your executor's fee.
Anyway.
You don't have to pay income tax on an inheritance. You get that tax-free.
So let's just pretend I'm another daughter in the family. I'm not the executor. When can I expect to get my inheritance if I'm, deemed to receive one by the will?
You know, there is no real set expectation. It depends on what the executor chooses to do, as well as what the court process allows. It's not going to be immediate unless there's a situation where we know there are absolutely no creditors. I mentioned before the creditors get paid first. Well, the thing is, if the executor makes the mistake and pays a creditor that they shouldn't have paid, or pays a beneficiary when they needed to pay a creditor instead, the court will hold the executor personally liable for that and ask them to pay for that
that just gave me
error
cold
out
chills.
out of their own money.
Wow.
So what does that cause the executor to do? Not make any distributions to the other sister or to any of the family members until they know that all of the bills have been paid.
Wow.
So one of the things that happens in an estate is we file that notice to the creditors that shows up in the paper.
Yeah.
And that's really a statutory process that says we have to notify those creditors. We have to give those creditors 90 days to come forward and say, I'm entitled to be paid. The good news is if there's a creditor out there and the family doesn't know about them and they don't come forward in that 90 days, that creditor is out of luck. And it's sort of like a bankruptcy process. That debt is discharged and we don't have to pay that.
Okay.
But on the other hand, we shouldn't be paying anybody until that 90-day period is run.
Got it.
And that 90-day period doesn't start when the person dies. It starts when we run the notice in the paper. And that is typically 30 to 60 days after the person died. So we're already looking at 120 days as kind of a minimum before anyone's going to get any distribution. And it's typically going to be more likely, 8 months to a year.
Well, all I know is I want to suck all that knowledge out of your brain because it's pretty phenomenal.
Well, let me answer one add one real
Yeah.
quick thing to that, and that is a lot of people plan with trusts as well. And when you plan with a trust, one of the things you do is bypass the court. And so you bypass a lot of these restrictions on the timing of distributions.
Okay.
And the trustee has a lot more flexibility as to when they distribute funds than does the executor.
So for those listening that might be feeling like this is just too much for them, or maybe they feel like they have a complicated situation, basically what is the role of a lawyer during this time period of after death?
Well, during the time period of after death, mostly, I think the lawyer is the person who knows how everything needs to be done.
Okay.
And different lawyers work different ways. Some lawyers will tell you when you come into the office and say, I need help with the estate, that they will help, but that means that they will do everything, and you'll just sign where they tell them to. And some lawyers will say, no, let's talk about what there is to be done, and the family will do some things, and the lawyer will do some things, and they'll work together. But I think the way the family ought to look at the lawyer, no matter what, and no matter who they choose to work with, is they want to work with someone who, will be first and foremost an educator. Explain to them the process and let them have an opportunity to understand what needs to be done. I usually think of what I do first and foremost is just putting the family's mind at ease that they are not going to get in trouble if they don't act promptly. They have no real deadline to start this process that they're likely to run up against. So they can take their time. They can grieve and then begin the process of dealing with the business if they choose. To be honest with you, I find the opposite happens a lot. What some people will do is throw themselves into the business of winding up the estate, kind of as a means of dealing with their grief. They want to get their mind off of their grief, so they want to take care of business. And I'm happy to accommodate that. I think that actually makes some sense. It's just not necessary from a legal standpoint. It's just a coping mechanism.
Sure. Well, I have to say, Mark, it has been an absolute pleasure. I appreciate you donating your time to really give your years of expertise to families that are really facing some difficult situations today that are watching. So thank you again for joining us. And
Well,
I just,
you're
it's
most welcome.
amazing. It's been great. Thank you so
Okay.
much.